good afternoon, everyone. Welcome to this webinar about Irini Katsirea's book, Press Freedom and Regulation in a Digital Era, a Comparative Study. My name is Sophie Turan, and I have the honor of being president of BACL, that is the British Association of Comparative Law, and it is our great pleasure to host this webinar. I'll say some very brief words about BACL before handing over to the chair of the panel. BACL was created in 1950 to promote the study and teaching of comparative law in the UK, and we will in fact shortly celebrate our 75th anniversary of the association with a comparative law workshop in Cambridge in July. We hold one annual seminar at the start of the Society of Legal Scholars annual conference this year at Leeds University in September 2025, a postgraduate research workshop almost every year, and our website welcomes blog posts in every shape or form on comparative law projects in whatever shape or form. So do have a look at our website. Do be in touch if you wish to collaborate and or are interested for publication on our website. And I'll put the link in the chat very shortly. And I'd also like to express my thanks to the Faculty of Law at Cambridge for supporting this webinar. And in particular, my thanks go to Daniel Bates. So our chair today is Professor Jake Rowbottom, Professor of Law at the University of Oxford, an internationally renowned expert in media law, freedom of expression, and the legal regulation of the democratic process. Thank you very much for chairing this webinar. And without further ado, over to you for chairing. Thank you, Jake.
Well, thank you very much, Sophie, and it's great to be here. And it's great that we're getting the opportunity to talk about Irini's book, Press Freedom and Regulation in a Digital Era. Hugely important work. It was published in 2024, and it shows how the old understandings of press freedom are coming under increasing pressure in an age of convergence, subject to new forms of regulation. And this has implications for the way that we define press freedom and what we expect the media to do. And I think this is a really rigorous, in-depth study, and it looks at media practices, and there's a lot of comparative law as well with various other European countries. So if you haven't done so already, I'd strongly recommend that you go out and read it. It's a great book, and we're very lucky today to be able to discuss this with Irini and also with our three panelists. We have Tom Gibbons, Emeritus Professor from the University of Manchester. We have Peter Coe from the University of Birmingham, and we have Professor Bernd Holznagel from the University of Münster. So what we're going to do is we're going to start off with Irini. You're going to talk a little bit about the book. Then we'll hand over to our three panelists for their comments and for their responses. And if anyone has any questions as we're going through, do post them in the Q&A section, and then hopefully we'll get a chance to go through those at the end of the discussion. So without further ado, I would like to hand over to Irini.
So thank you all for attending, and thank you to the British Association of Comparative Law for hosting this discussion. In recent times, concern about the online circulation of content that could harm individuals and society at large has triggered a regulatory turn. A race between nation states and the European Union as a latecomer to design policies to render platforms more accountable to the public interest. Some of these policies target platforms' market dominance, while others address the content they distribute. They are crafted amid uncertainty about whether platforms are media companies or mere conduits. By remaining wedded to regulatory models from the analog era, they risk failing the test of time. This flurry of regulatory activity is not surprising, as it comes at a threshold moment in history where norms of civility, media formats and standards, and our very understanding of what is the media and what are facts are in flux. The regulatory turn bears promise, but it also poses risk. This book argues that electronic news media are increasingly seen as vectors of the same harms that beset the internet at large. They are hence gradually transformed from technologies of freedom to refer to the solar pool to technologies firmly placed under the tutelage of the state. They are also subjected to online platforms' moderation decisions. Whether human or algorithmic, these decisions pose the risk of collateral censorship, as aptly phrased by Jack Balkin. The extent to which online news publishers should be shielded from platforms' moderation practices, as under the Online Safety Act or the European Media Freedom Act, whether they should be granted or denied media privileges, or be subjected to journalistic due process, vexes legislators, courts, and media authorities alike. The legal classification of new media is often informed by regulatory categories from the past. Is an online news portal similar to a print publication? Is it more similar to a TV channel when it contains a dedicated video section? Are public service broadcasting websites press-like when they include non-program related written content? These comparisons continue to hold sway in the digital era and to influence the way in which real or perceived competitive battles are fought out, or to even determine the future of the internet as we know it. They have a superficial attraction not only for policymakers, but also for the courts. In Germany, the Administrative Court Berlin denied an investigative blog, Faktenstadt.de, the right to access to information held by the federal authorities on the ground that it was only published online and could therefore not claim the right to press freedom. The blog had published 2,000 copies in print so as to assert its right to information. The regulatory framework for the digital press is influenced by the overarching European framework, as well as by idiosyncratic national factors and constitutional traditions. The emphasis in this volume is on the European Court of Human Rights and the Court of Justice of the European Union case law, and on the domestic legal orders of the UK and Germany. Ad hoc comparative insights from the US serve as a useful, albeit not comprehensive, counterpoint. The comparative method has served to provide added value in three ways. First, by comparing jurisdictions that are forerunners of digital platform regulation in Europe. Secondly, by comparing the emergent regulatory model for digital press with categories from the analog past, in particular the regulatory frameworks for broadcast and print media. And thirdly, by comparing traditional journalism with citizen journalism. In the UK, non-traditional online journalism is mostly unregulated, while in Germany, online news portals, so-called journalistic editorial telemedia, have to comply with journalistic due diligence obligations. One of these ethical obligations that has held great sway in recent times is the duty of accuracy. Whilst it is right that the legacy media should be held to high standards of accuracy, it seems inequitable to impose such exacting obligations on ordinary individuals whilst depriving them of the right to information. The unevenness between benefits bestowed and burdens imposed on the yet indeterminate category of other non-traditional journalistic actors is a theme running through the book. I was further interested to explore if regulatory ruptures, incongruities between regulatory models are in the process of becoming overcome, or if they will forever remain as relics of a bygone era. And is it desirable that we should hold on to them? The standard of impartiality is especially challenged in an era of live blogging and opinion-based journalism, and it has repeatedly been tested in this country by politicians acting as news presenters. The regulatory framework for the online press is further complicated by the extension of platform logics to its domain and by its subjection to obligations germane to online platforms. Prominent examples are the extension of the right to erasure to online news archives and the imposition of intermediary liability on the comment sections of online news websites. When I started the journey that culminated in this book, I thought that the press perhaps enjoyed undue privileges compared to other media forms. And I was curious to find out what the brave new digital world might hold for this spoiled child of media regulation. I have concluded that the paradigm of a fiercely free, self-regulated press in tandem with that of a more constrained, externally regulated broadcast medium is precious and needs to be preserved in the new media environment. I will stop my presentation here, and I'm afraid that I've raised more questions than provided answers. But we have a great panel with us today who I'm sure will share the perspective on some of the issues covered in the book and on the nascent regulatory framework for the digital media landscape. Thank you for your attention.
Okay, thank you, Irini. And that's in a space of a few minutes. I think you conveyed the sheer complexity of the issues and the number of moving parts that are at stake here. So a lot for us to discuss. So to start this off, I'm going to hand over to Tom Gibbons. Tom, do you want to start off with your comments here?
Okay, yes, delighted to do so. As we've just heard, Irini has produced an excellent documentation and critical analysis of the way that what's really a set of technological path dependencies has dominated regulatory approaches in the transition from traditional to digital media outlets. And it seems as if there's no way to ease the tensions between the old and the new when attempting to reconcile them. I really suggested that I might devote my comments in this seminar to three questions that her study raises, and my fellow contributors will deal with other questions, other issues. Her questions, I think, have this in common, that they reflect a sentiment that in attempting some kind of reconciliation between the older form of regulation and the newer form of regulation, reflecting the technological changes, that some sacrifices will be required and that the resulting burdens will have to be evenly balanced between the traditional and the new. So just I'll quickly tell you what the questions are, and then I'll tackle them one by one. So the first question is, she asked, is there a risk that online news media will be transformed from, quote, technologies of freedom to technologies firmly placed under the tutelage of the state via the fiat of all too powerful media corporations? The second question is impartiality a norm of the past? Are journalists' use of social media and the BBC Local Democracy Reporting Service, for example, compatible with this norm? And then the third question is the argument for public service broadcasting strengthened or weakened in the digital era? So if we take the first one, is there a risk that online news media will be transformed from technologies of freedom to technologies placed under the tutelage of the state? I think the quick and easy answer here would be to say yes, and to offer a set of compromises to accommodate the risk. And indeed, Irini's work shows how difficult that is and demonstrates how many inconsistencies and difficulties there are with attempting that accommodation. I don't underestimate those, but I think it's important to take a step back and to examine the possible assumptions underlying the problem. I think the main one seems to be that a digital environment can, on the face of it, enhance the availability of unrestricted press content, and that existing attitudes to press freedom should be preserved in that new environment. I think actually the new environment should force us to reconsider what kind of press freedom is desirable. And of course, this will be controversial, and the reason it hasn't been considered so far is precisely because it is so controversial. Hitherto, I suggest, an uncritical notion of the free press has dominated. It's one based on the negative right of proprietors and journalists to resist any interference with their freedom of speech. This is an uncritical notion of a free press, and it's had the effect of diminishing its de facto function as a platform, a legacy kind of platform, if you like, for the dissemination and consideration of information and viewpoints. And the press industry has exploited and resisted attempts to take responsibility for its platform character. Inconsistencies in press electronic regulation, so regulation of the press, regulation of what you might call the electronic media more widely, they expose underlying failures to identify and reflect in regulation core values and principles around journalism. I've argued elsewhere that a stronger conception of the right to free speech might help in these circumstances. A right to free speech that's based on merely a negative idea that you shouldn't interfere with press speech fails to recognize that the primary social interest in speech and ultimately its justification for protection is to enable dialogue with others. Of course, it's possible to speak and not encounter others or not engage with them at all. But if you see the actors engaging in speech as social actors, as members of society, the whole point of speech is to enable some kind of interaction with those others. And that implies access to platforms to engage with others. In the past, in the analog era, there was quite a movement and quite a literature about so-called access to the media, and that was a recognition that the press didn't really concede in any meaningful way at all. That in the old days, old-fashioned paper newspapers were themselves, of course, platforms. And to engage with others and others' viewpoints on those platforms, you have to think of some way of enabling different perspectives to engage with each other. Now, the thing is, I believe that request or that claim for access actually reflects good journalistic values. Journalism reflects a number of news values, of course, and we shouldn't think that we're only concerned with a kind of highbrow version of journalism here, a highbrow version of news. So there might be many reasons why journalists will pursue stories, mere entertainment, nosiness, gossip, but also analysis of the state of the world and of particular relevance, the implications for our own democratic values. So journalism, what might be called good journalism, I think is characterized by a critical appraisal and analysis, an interrogation and challenging of opinions and positions, which is just the sort of thing that would require interaction with and dialogue with others. Journalism is more than the mere conveyance of ideas or the conveyance of information, although of course it includes that, and that is very important. And the old readers and now the users of news will want all those things. Journalism, however, I think can be seen as a proxy, or a good version of journalism can be seen as a proxy for access to the dialogue that a strong conception of free speech entails. So the impetus to incorporate some regulation of digital press content into wider regulation of digital platforms can be seen as an opportunity for good journalism to be articulated and to be protected somehow in law and regulation. These kinds of issues have played out in fairly recent discussions. In the UK, we had the Leveson inquiry, some attempt to articulate values and incorporate into self-regulation was attempted, but in my view, has singularly failed. The Cairn Cross inquiry into the press considered the matter also, and in submissions to that, as Irini explains, the Arts Council suggested there might be such a thing as an Institute for Public Interest News. We have widespread discussion within the under the auspices of the Reuters Institute about various aspects of good news. BBC, the British Broadcasting Corporation's College of News tries to articulate its values internally, and more internationally, as again Irini explains, the Council of Europe has a widespread discussion about these issues. Nevertheless, the press industry has resisted the idea that it should embrace the idea of aspiring to good journalistic values, and it insists that it has the right to be, if you like, disruptive and almost sitting on the edge of law and resistance to the status quo. And of course, journalists will say that that is one of the powers of journalism. That is the way that it can resist tyranny and oppression. And I don't think we could deny that. The question is there a more positive way of engaging with good journalism and making it work for the good? And I would say in passing that all this requires, in addition to incorporating press, some form of good journalism into the regulation of digital media, also requires a good financial foundation. So some kind of funding for good journalism needs to be implemented as part of this. The second question that Irini asks is impartiality a norm of the past? Are journalists' use of social media and then she goes on to mention the BBC Local Democracy Reporting Service compatible with this norm? This is where, well, let's take it one at a time. So, is impartiality in the presentation of news something of the past? I think not. I think it's still relevant and actually very important. I think the rationale has changed over time. It's not so much these days the impact of coverage, but the curation of the sheer mass of information that is now available across the internet and in digital form. I think the underlying principle remains to prevent audiences and users from who are experiencing news from being dominated in that experience by a single or a powerful perspective. When it comes to operating impartiality, my own view is that some kind of institutional culture of support for news impartiality is better than attempting a legal definition. And I think that where impartiality is articulated in hard and fast rules, as Ofcom has attempted to do, and then is litigated, as in the recent case that Irini mentioned, you get a rather mechanistic approach to impartiality, which is something that really involves a judgment about fairness and even-handedness in presenting news. And here I think an institutional affiliation, institutional support and a reputation for impartiality is much more powerful than implementing or enforcing legal rules. I think that this ties up, of course, with the need for some kind of funding and for some kind of support for journalistic operation of an impartiality requirement. I think the issue behind this second question is really whether, as indeed it really has flagged up, is whether press-like partial opinion and editorializing should be permitted on electronic media. In my view, it should, but that is not to accept that legacy press privileges should simply be incorporated into the new approach without modification. I don't see any problem in principle with partial news coverage, provided it is complemented in some way by positive measures to signal alternative sources. This is not, I think this does not involve imposing a hierarchy of preferred speech, valuing some content above others. This is more about reflecting the diversity of news values, which I mentioned earlier, for all kinds of news content, not a claim that highbrow news and intellectual news is preferable. This again requires some kind of, it requires a mechanism of flagging up different kinds of news sources. And what it is to avoid in a more sort of colloquial, by way of a colloquial example, is to avoid a situation where we have a digital media environment, news environment, modified by channels such as Fox News and others, which are so partial as to exclude alternative and more dispassionate versions of the news. I suspect that others will comment on this more fully. For myself, I should just mention that I'm not so convinced that citizen journalists should have a special status in all this. I think an institutional focus on professional, although they deny that they're professional and see themselves as citizens, professional news operation, it should be the main focus of any terms of regulation here. The development of the internet and social media, of course, presents all sorts of problems, which Irini has documented in her book, and we're all aware of the difficulties with jurisdictional problems caused by the fact that most of the internet is dominated by a jurisdiction that has a very, very absolute free speech approach, namely the United States. And the large corporations that are based in the United States and their power over dissemination of information. But I think the possibility of regulatory support for a diversity of news should not be dismissed. It's too easy to be convinced that the technology is so deterministic. And I think there is a momentum in the shift to regulation of online safety, for example, that can be explored. One that can require prominence and access to alternatives. I wouldn't dismiss the difficulties involved in this, and particularly increasingly the difficulties in trying to shape the algorithms that such measures would require. But I think approaches that require providers to deal with that, to produce an effective result, might be the way to go. And I do agree with Irini. I thought I would just emphasise this. When Irini says, towards the end of the book, she says, it is necessary to develop a positive regulatory framework as opposed to only negative measures aimed at tackling competition imbalance or harm. Such a framework would foster a digital environment in which everyone has access to diverse, financially sustainable public interest news media and is empowered to participate in democracy. So I agree with you on that, Irini. On the sub question in this second question, what do I think about the journalists' use of social media and the BBC's local democracy reporting service? I think that the idea of a public service journalism outlet subsidising the commercial press is one that should be removed as soon as possible. The existence of this service, this BBC reporting service, was the side effect of an attempt to cut back effectively public service funding for the BBC by British government, and I don't think it's compatible with public service values. Let me turn to the third question then. Is the argument that
shall we leave some of these to the discussion, maybe, if we move on to go to the next panelist, because we've got a limited amount of time. So if we move on, I mean, I thought it was really interesting. It also shows just the sheer persistence of some of these questions and how they're not going away. You know, question about how we define the media, what constitutes good journalism, the media as a platform. These are all long-standing questions that remain persistent despite all the changes. But I do want to move on. So thanks very much for your comments, and hopefully we can revisit some of those things in the wider discussion later on. But if we go over to our second panelist, Peter Coe, I think you're going to talk a little bit about misinformation and disinformation. So thanks, Tom, and over to Peter.
Cheers, Jake. Thank you very much. And Irini, just to echo what Jake said at the very beginning, you know, this is a really important book and it's a tremendous achievement. So well done. I've had the privilege of reading it, and just to give it another plug, I would recommend it to everybody. So yeah, really well done on the book. So Irini's asked me to consider two questions, which I will deal with in turn. The first question is, does the regulation against mis and disinformation pose a threat to press freedom? And in my view, there are two facets to this question which we can consider. Firstly, false information is synonymous, as we know, with certain factions of our press, and we all know that press barons historically and in the current day have used propaganda to advance their own agendas. And also we know that the lucrative trade in celebrity gossip in our tabloid press provides an example of the use of what is often untrue or only partially true information for financial gain. Now, today the internet and social media provide the ideal environment for false information to grow and to spread online and offline. And just going to Irini's point at the very beginning, that electronic news media can be vectors of some of the harms we see on the internet at large. My view is that this is amplified by the symbiotic relationship that exists between online content and certain factions of our media, as it's often used as a source of news. The fact that trusted mainstream media publish what may be false information serves to justify and support that information, which creates a self-fulfilling and insidious cycle. And this situation hasn't been helped in recent years by the state of our press industry. This has led to faster and shallower corporate journalism, necessitating the need for newspapers to provide news 24 hours a day across multiple platforms. And this, combined with fewer journalists and an increasing reliance on clickbait and sensationalist headlines to generate clicks and advertising revenue, encourages the recycling of information, which can lead in some cases to fast and loose journalism that sees source and fact checking being cast aside. And this results in more mistakes, including the inadvertent dissemination of false information. And ultimately, this has contributed to a precipitous decline in the trust that we have in our newspapers, which recent Ofcom news consumption surveys tell us has resulted in people going to other, usually online sources for information, which in turn contributes to the vicious circle that the press industry finds itself in. And it becomes essentially a bit of a race to the bottom. Now, this, of course, does not create the environment that the press needs to exercise its freedoms and to meet the obligations that come with those freedoms. So on the one hand, the effective regulation of false information could help the press and the public sphere by contributing to the restoration of public confidence in the press. But on the other hand, and this is the second facet to this question, as Irini sets out in her book, the distinction between different types of false information, so disinformation, misinformation, malinformation, isn't always clear. By regulating against false information specifically, we could end up with regulatory overreach, resulting in, for instance, newspapers and publishers being reprimanded for publishing false information by mistake. And as Irini says, it's difficult to always draw a line between the intentional dissemination of false information and that done by mistake. As Irini says, we shouldn't tar all publications with the same brush. It may also result in newspapers choosing not to publish important public interest information for fear of regulatory sanction. They may err on the side of caution, especially when we bear in mind the financial state of many publications, and also when we think about smaller publishers and citizen journalists, their lack of legal support that they have around them. And ultimately, this would have a detrimental effect on the exercise of press freedom and the health of our public sphere. And let us not forget that there is already an albeit voluntary press regulatory scheme in place, which requires regulated publishers to adhere to respective accuracy codes under IPSO or IMPRESS, although I acknowledge there are problems with this. And of course, such content may also be covered by the torts of misuse of private information or defamation, for example. But again, I do acknowledge the problems with this. Now, in my view, there isn't a silver bullet for tackling false information. It's existed for centuries. It's always going to exist. And so long as we've got the internet and social media, it's going to be pervasive and invasive. And I'm not convinced that specific regulation is the right way to meet the challenges we face. History tells us that the law and regulation to deal with false information tends not to be that effective, largely because there is often a tension between misinformation in particular and free speech laws and principles, including press freedom. So in my view, when it comes to something as amorphous as false information, the rigidity of legal regulation means it's probably doomed to fail and may actually make things worse. In my view, we probably need to find better ways of living with it. It's always going to be here, like I said, and there is no one way of doing this. But I think there are, and I would acknowledge, imperfect and maybe slightly idealistic more speech solutions that I think can be deployed to improve our situation. And I think, that starts with, improving education and digital and media literacy. So that's my views on question one. I'm going to turn now to the second question that Irini has asked me to look at. I was just checking my time. The second question is it possible to effectively ring-fence journalism without undermining press freedom when regulating online platforms? And this is a big question, so I'm going to try and tackle it as best I can do in the time that I've got. And I think ultimately it depends on how we ring fence it. So to answer this question, I'm going to focus on the problems with the recognised news publisher exemption in the Online Safety Act. So the Online Safety Act mandates that services it regulates privilege press content. And it does this through its exemptions for recognised news publishers, which among other things takes such publishers outside of the Act's remit and ensures regulated services don't over-moderate the content these publishers produce. News publisher content posted on Category 1 services, so these are your Facebooks and Instagrams and X's, doesn't fall within the scope of the regime. And the Act exempts such publishers from its newly created false communications offence. Under the regime, a recognised news publisher can be an entity that publishes news-related material that's created by different persons and is subject to editorial control, and which publishes such material in the course of a business, is subject to a standards code, has a registered office or other business address in the UK. So therefore, news-related material is defined as material which consists of, among other things, gossip about celebrities, other public figures, or other persons in the news. So the Online Safety Act provides an institutionally conceived exemption for members of the legacy press to publish content that may be based on false information and which goes to the core of the trade in sensationalised news and gossip. In doing this, rather than protecting us from false information, the Act could contribute to the distortion of the public sphere, as these false stories often become the dominant narrative. Now, significantly, the Act is problematic for independent journalists. By stipulating that recognised news publishers must produce news-related material that's created by different persons, is published in the course of a business, and has a registered office or other business address in the UK, it privileges legacy journalists. And in doing so, it potentially excludes many independent journalists from the exemption, because many work remotely, they can be based abroad, and or they're run by a single person, which is often the case for those hyper-local publishers. And in the case of many citizen journalists, they're not necessarily operating in the course of a business. Now, although many independent journalists will not be captured within the Act's institutional exemption, what they produce may still be subject to the Act's duties imposed on Category 1 services to protect journalistic content through their moderation systems and processes, which Ricky Liga-Brandt, in an excellent recent article in the Journal of Media Law, has called a functional content-based protection. However, the level of protection afforded by the provision falls short of the recognised news publisher exemption, rendering independent journalists underprotected when compared to members of the legacy press. This is because the duty only requires services to take into account the free expression of journalistic content when making decisions on how to treat such content and whether to take action against a user generating, uploading, or sharing such content. So this means that for independent journalists not captured by the Act's institutional protection, regulated services may simply pay lip service to these softer duties when a conflict arises with the legislation's harder-edge safety duties. The Act mandates that services include in their terms of service provisions specifying how the importance of the free expression of journalistic content is to be taken into account when making decisions in relation to the duty. Because of this wording, services may simply produce template policies that say those services have taken into account the protection of democratic or journalistic content. So long as they can point to some decisions where moderators have had regard to or taken these duties into account, they're going to be able to demonstrate their compliance with the duties imposed by the Act to Ofcom. It may be very difficult or even impossible to interrogate the process. Moreover, and significantly, in contrast to the institutionally privileging recognised news publisher regime, regulated services are not required to notify users when action is taken against journalistic content. Rather, the journalist or person who uploaded or shared the content would have to complain to the service. This is really problematic when you consider that the journalist may be unaware that action has been taken against the content, and all the time it takes for any complaint to be addressed. So even in the event the content is incorrectly taken down and then reinstated, the time lapse between removal and reinstatement may impact on the public interest currency of the content. So just in conclusion then, ultimately, this has the potential to significantly restrict the ability of independent journalists to effectively exercise press freedom, whereas there are a number of exempt entities that profit from publishing celebrity gossip and potentially false information. Therefore, inadvertently, the Act could contribute to the marginalisation not only of these types of publishers, but also to the individuals and the communities they give a platform to, including minority and underrepresented groups. And in doing so, it could disproportionately impact on certain types of reportage and information. I will leave it there because I think I've just gone over slightly, so I do apologise, Jake, but that concludes my answers to the questions.
Okay, thank you very much, Peter. I think really showing some of the complexities that we have there when we try and implement regulation and potentially some of the unintended consequences that can arise, say, for example, when you try and ring-fence journalism for protection. Before we move on, just a quick reminder, if there are any questions, do please post them in the Q&A and we'll visit them after the discussion. But I'm now going to hand over to our third panelist, Bernd Holznagel, from the University of Münster, and I believe you're going to talk a little bit about the asymmetric nature of the regulations. Bernd.
Thank you very much. And the question is, do you understand me? I have here a wrong sign, yeah. And the basic question is whether the asymmetric regulation is sustainable. And there are different angles where this traditional concept is attacked. One, for example, is newspaper video online services. And I think, however, that asymmetric regulation of the press and broadcasting has proven its worth. There is currently no apparent reason why this should be changed. A license is required to engage in broadcasting activities. There are graduated standards for content which are monitored by an authority, Ofcom, or in Germany, the Landesmedienanstalten, responsible for broadcasting. In order to protect the business model of the press, public broadcasters are, however, limited. They are not allowed to distribute text, forums, and chats. And there is only one exemption if these chats or texts are very closely related to the program. Online advertising is prohibited at all by the public broadcasters. In the press sector, however, press self-regulation by the Press Council in Germany or IPSO in UK is the main form of regulation. Insofar as the press distributes audiovisual content, the regulatory authorities have largely refrained from implementing their instruments. In view of its economic difficulties, the press should not be further burdened with regulation. However, there could be a change of the traditional regulatory concept. In Germany, we discuss now to establish a digital open public sphere. Why are we discussing this? There is a general mood that the traditional global platforms cause or endanger public discourses, and the idea is now to organize the public sphere, for example, by the public broadcasters. We have a study has been published recently, and this study argues that the second German channel shall act as an enabler and organizer of a digital open public space, and if you are proceeding and trying to implement such a concept, you have to erase all these limits we had between all these borderlines between the press and public broadcasting. For example, it would be necessary to quit all these rules that public broadcasters should be banned from forums and chats. Irini, your book is excellent, and the German information is just to the point. So you know many more cases than anybody of the panelists. Congratulations. And you actually do mention that the press in Britain is somehow being an enabler of this public discourse concept. I don't know whether this is true. You just mentioned this issue, but I've heard that, for example, in Austria, the standard is fulfilling such a role of an enabler, and the beginning of of thinking about a new concept is precisely what we just heard from Peter, that these algorithms, they are now not producing an open debate, but they're destroying what we do have, and they are destroying public discourse. And that's, let's say, the beginning of thinking of a new concept. Whether this is true or not is debatable, but it is at least the argument of, for example, of many colleagues now, of your age group, basically, in communication sciences. So, however, there are also other areas where the old regulatory model has some flaws. Another issue is, for example, these liability rules. And the question is whether the liability rules are somehow a threat to the traditional role of the press. However, I think this issue is resolvable. Media companies must, however, exercise with caution when they publish user comments. The company is strictly liable if it adopts the comments as its own. I think that is everywhere the same. It becomes, however, if it becomes aware of legal content, the content must be removed promptly. However, there is no rule and no general obligation to carry out prior checks. These two major principles are, I think, fine, and they do not pose a threat to the business model of the press or the democratic function of user comments. What has to be done in this area is a balancing, and at least in Germany, but if I understand Irini's book correctly, also the British courts try to balance the different interests, the personal rights and the rights of the press or the media. And what I can see is that they found reasonable solutions. I do not see that there is a fundamental shift of legal rules necessary. The third issue you posed on the table is the question, what is going on with data protection and personal rights? And there is, in fact, a problem, because in the Google Spain ruling, the European Court of Justice gave data protection a higher importance than the right of media freedom. And this ruling has been, however, vehemently criticized by the German Federal Constitutional Court. And actually, they were starting to fight the courts, and they had different meetings, the German court and the European court, to reconcile this debate. In Germany, the courts insist to give the right of privacy or data protection and the freedom of the media equal importance. And they insist that individual cases must be weighted up against each other. This has been done in Germany for more than 30 years, and I think this is widely accepted by the press and the general public. And also in this area, at least from the German point of view, I do not see that it is necessary to have a change from the present legal situation. So I do not believe that this right to be forgotten is of such an importance that press freedom is threatened. Thank you very much.
Okay. Thank you, Bernd. Irini, I hope you've had a chance to, well, thanks to all three of our panelists as well for the comments there. So a lot of issues are put on the table. Irini, I don't know if you've had a chance to process all of that, but you have a few minutes to respond to those comments. So Irini, over to you.
Yeah. Well, thank you very much for your thoughtful comments and for having engaged with my book so thoroughly, and also for your kind words. Starting with Tom Gibbons' presentation, I was particularly interested in the fact that the word funding came up a few times. So the need for some form of funding for good digital journalism. And I'm wondering where this funding would come from. So I think that's a question that needs to be addressed. There have been attempts to, well, online platforms have come in to plug the hole in the coffers of the press. And of course, this creates different problems of its own because it creates a relation of dependency between news publishers and the big platforms. And so it is not entirely without strings attached. So I wonder whether there are any ideas that we could come up with in this discussion that would contribute to alleviating the problems the press is facing. I also noted on Professor Gibbons' comments about impartiality, and that it is important to preserve this concept of impartiality in the digital age. And I agree that it does constitute an important antidote to so much opinionated forms of journalism and generally in a polarized online landscape. It is also an indication of how rival media systems can profitably work together, meaning an opinionated press more largely and a more balanced form of broadcasting. However, we have seen that impartiality has been challenged. And again, Tom mentioned the need for some form of funding for impartiality requirements. And again, this brings the issue of funding to the fore. I was also interested in your comments, Tom, about the need to espouse both highbrow news with other forms of news. And I agree that the concept of press freedom needs to be open, covering all sorts of news and covering different needs in society. And I generally think that ranking news according to their qualities, their bad idea, especially given that it would pose the question as to who would undertake this form of ranking. And the German Constitutional Court has been particularly specific on this point, that press freedom needs to be open to all and not undertake distinctions of quality. Moving on to Dr. Koh's presentation, I appreciate your concern about what you called an insidious cycle between mainstream and social media. And I think that this is particularly pronounced given that mainstream media increasingly monitor user attention to social media and try to replicate topics and themes that are viral on social media, to pick them up in their reporting. And I think this poses an extreme risk of a downward spiral for news journalism if they don't strive to rise above the level of discussions on social media. With regard to the problem of mis and disinformation, I agree with Pete that the concept of false information is an amorphous concept, and I think it poses great risks depending on how falsity is policed. It can pose great risks to freedom of expression and press freedom. We see that the current US government has, perversely, one would think, come to to the fore as rescuers of freedom of expression, and has what's the word, jawboned online platforms to abandon their fact-checking operations they've had, based on the argument that this stifles freedom of expression. However, it is more than apparent that the Trump government is not really interested in freedom of expression. So again, the divide between truth and falsity is being utilized allegedly to save freedom of expression, but there are great concerns that this is not the real motive behind. So falsity can be a tool to for many ends, and there is a rise in laws in Europe and further afield, laws criminalizing false information, and I think that this is of particular concern. Yeah, with regard to the ring fencing of recognized news publishers, this has been the attempts in the Online Safety Act to ring fence recognized news publishers have come under particular attack in this country as a tool to shelter the bad elements of the press and provide a cover-up for disinformation. I can't say I totally embrace this criticism, in the sense that I understand the motivation of trying to protect valid journalism from certain excesses by online platforms that are often driven by an algorithmic mode of operation that can't really distinguish the context. And so I understand the motivation of these attempts in the Online Safety Act, but of course it faces the extreme difficulty of distinguishing between, and it raises the question of what is news and what do we want to protect. And of course this is an intractable problem, as Pete also said. Finally, turning to Professor Holznagel's presentation, I'm particularly intrigued by the experiment that is currently carried out in Germany to create a digital open public sphere, and the notion that in such an open public sphere, the limits between broadcasting and the press would partly need to be loosened or even erased. I think it is a very attractive proposition to try to create a counterweight to the extreme monopoly of online platforms, and create a space that is more transparent and more wedded to the public interest rather than only to profit motives. So I hope that this experiment will be fruitful and will create a model for other countries. With regard to liability rules and liability on online news providers, this is an area that the European Court of Human Rights has struggled a lot with, and cases keep coming, and they're not so much now about legacy media, but about the single blogger and their account, and in how far they should be liable for comments posted by others. And there the case law is far from settled, and there are contrasting decisions by the court. The latest one, Petrascu versus Romania, where the European Court of Human Rights has sided with the blogger and his right to post these comments. With regard to the right to erasure, yeah, it is a right that has been more embraced in Europe than in the US, where it is totally alien to the First Amendment conception. And I do agree with Bernd Holznagel that the view of the German courts giving equal protection to freedom of expression, personality rights is a preferable one than trying to accord personality rights a higher rank. Well, thank you all so much for your comments and for the very stimulating presentations.
Okay, thank you, Irini. We've got a few questions that have been posted. Let's start off. We've got one that's in the Q&A. It's from Richard Danbury, and I don't know if this is directed to anyone. I think it was posted, Tom, while you were presenting, but I guess I can open this up to anyone. It's about who regulates. It says, would it be worth investigating the possible dangers of this sort of regulation? For example, capture of the regulator by the executive. Boris Johnson trying to appoint Paul Dacre as head of Ofcom, and in many other countries, press regulators seem to exercise the will of the government of the day. So I wondered if we had any thoughts on that. Does anyone want to respond to that particular question? About who regulates and the risks involved?
Well, I'm not sure it's a direct answer to the question, but I mean the problem of capture of regulators has, you know, it's been there for a long time in regulation, and I think there are two ways to deal with it. Which are perhaps wasn't too obvious to say. One is transparency in the process, and the other is political support, and by exposing attempts, as happened in the example that Richard gave, attempts to take over or wrongly influence a regulator, the public reaction is itself a very important form of enforcement. So I think as well, if there are some, these sorts of problems arise if there aren't clear notions of what is wanted to be achieved, and this is where a much stronger from the press itself, from journalism, rather than the press as an industry, but from journalism, to assert what is good journalism, and to enable journalists, whether professional or indeed working as independents or freelancers, to be able to align themselves with these values, provides a basis for resisting these attempts at censorship. I'm not saying it's an easy process. It has to be about political will.
Great, thanks, Tom. Anyone else want to come into this, look at this particular question about who regulates? We can talk a lot about how we regulate and what rules we have, but I think it is often overlooked about who actually has the power and who's making those decisions. If no one else wants to come in, shall we move on to the next one? Okay, so the next question, Irini, I think this is directed towards you. This is from Claudina Richards, who says, path dependency is often raised as a constraint or as shaping regulatory models, and you consider this in your study. Is path dependency, in the context of your study and each of the countries studied, a safeguard or an obstacle towards this nascent digital constitutionalism you mention in your book?
Yeah, I think path dependency is understandable in the sense that creates an anchor, something tried and tested to replicate in the online space. And I see sense in the way these models have been shaped, and the balance between freer press and a more restrained broadcasting model. I just note that there are instances where drawing the line between the two and holding fast to these rigid distinctions can pose problems in the digital domain. And I think two areas that I talk about in the book on the one hand, the video content of press publishers online, where regulators have struggled as to how to classify this, and whether it means that online press should be regulated in a similar way to broadcasting. And while this option is open, it hasn't quite materialized, at least not in the UK. But there are still many unanswered questions as regards, for example, video content posted by press publishers on video sharing platforms or streaming services, and how to handle that. And I think very mechanistic approach that looks at criteria that are used by regulators, like whether the video content is closely linked to press content, for example, how extensive the video content is, etc. They serve legal certainty, but they might not be the ideal criteria to make decisions on these issues. And the other area is public service broadcasting. That is, of course, in competitive battle with the press, both in this country and even more so perhaps in Germany. And I think, again, that these attempts to very finely delineate the domain of press and broadcasting online is not very fruitful, and that the criteria they use to do that are not really conducive to a vibrant public sphere. So in that sense, I find the notion of a public space as that is attempted by public service broadcasters in Germany, where everybody can coexist without these competitive battles always being fought out, an attractive one.
Okay, Professor Holznagel, do you want to comment on this as well?
I think that the regulatory models and the recent cases, they are really depending on, they are path dependent. That is, I think if one reads closely to your book, it's very clear that the borders blur, but the whole concept is still somehow stable. I personally think that we are coming to a, how do you say it? In Germany, we would say a Kipppunkt, yeah, Kipppunkt, that the whole system turns. And there are basically two developments that are undermining the system. One is that the business model of the press doesn't work anymore. And the other issue is what you were mentioning, that public broadcasters, but also the press, had the task to organize a public sphere and to argue and find the best solution for the society. And we are observing now that this platform-driven communication is destroying the communities, is destroying rational debate, is what Peter has argued very nicely, brings us disinformation and so on. So these two developments, they need a more profound answer, which really destroy this path-dependent models in a specific way. And the debate that has just started in Germany, you see, I do not think that the new model has been worked out properly at the moment. But for example, if the press and the broadcasters are both responsible for organizing a rational debate, why not finding incentives so that they can collaborate to reach this aim? Yeah, that would be one issue. The other issue is, as I mentioned, I think both societies, the Britain one and the German one, we have limits for broadcasters so that they cannot enter the press field, if you like, and we have to rethink this. And maybe last point, if the vision is really this public sphere vision is something we could agree on, it's not said out from the beginning that this should be organized by broadcasters. The German debate runs into this direction because they have the money, yeah, but it could easily be organized by the press. And I gave this example from the Austrians, from Der Standard. Maybe the press could do better. It could be probably done better on the regional level. And I personally myself wondered why the ZDF, as the national broadcaster, brought these new ideas at the table. It would be easier to organize this in, let's say, some Länder from the beginning, and then try to experiment and so on. But it's something new, and that is needed.
Okay, thanks. So I think we've got one last question here, but we can fit in if we have a fairly brief response. Irini, it's directed to you and from Sophie Turan, asking, what were the challenges in developing a comparative analysis between the US, UK and Germany? Any surprises? You also mentioned Helena Mancini's study classifying the UK and US as representatives of a liberal model. Are the typologies like this broadly accurate today?
So, yeah, thank you, Sophie. I mean, a comparative study is, of course, always very challenging and very time-consuming, but also very rewarding because it holds up a mirror to a different system, and there's so much to learn from seeing different ways in which common problems try to be solved and are tackled. And often it is astonishing how the problems are very similar from one country to the other, even if the solutions differ somewhat. With regard to the UK and the US, yes, they're both liberal models, and there are commonalities between Europe and the US that can be underestimated, because usually the US is seen as posing a problem, having allowed, for example, these tech giants to grow with its very liberal attitude and very robust First Amendment protections, etc. But the reality is that even in Europe, where there are increasing attempts to regulate platforms, the backbone of immunity from liability for platforms that also applies in the US also remains in Europe as a core part of, for example, the Digital Services Act. Yeah, there are differences that are mainly come down to the different constitutional tradition in the US and the perhaps extreme protection of freedom of expression there that becomes more obvious in the digital sphere. But there are also certain commonalities that shouldn't be forgotten.
Okay, I've got a few minutes remaining, and that allows us to go back to the panel for any concluding observations. I'll take it in reverse order. So if we start with Professor Holznagel, were there any concluding thoughts? If we have just a few brief remarks, if you have any to share with us. Or am I putting you on the spot here?
So I think now it's working. I think that Irini's book is an excellent overview of the, how to say, the recent issues and debate in this convergent environment. I think there is no doubt. In some areas, it's almost too detailed because it goes into the issues in a depth that I hardly know somebody who really knows so many cases so deeply. The issue that is somehow missing is are there more radical concepts to find solutions? It's a little bit, from my point of view, too much path rooted, which is a compliment somehow, because the book must have been, you probably wrote on this book for a long time. And therefore there is no option. Maybe organizing a blog after such a debate is also the right way to think on radical terms now and what we can do. But it is an excellent basis for further debates. And you have many screws where you could now start to develop the system further if you read through Irini's book.
Okay, thank you. Peter.
Yeah, thanks, Jake. Thanks again, Irini. I think the last 1.5 hours or so, and these discussions that we've had really have just demonstrated the sheer complexity of our communication ecology, and I think it's only going to become more complex and more difficult as time goes on. And in my view, Irini's book manages to navigate these complexities really well. It's incredibly comprehensive, it's incredibly well written, it's very clear and accessible. But I think really this is just the beginning of a discussion that's going to continue, and I think Irini's book highlights so many different issues that we as academics can probably dine out on for a number of years to come. So I will leave it there, but very well done again, Irini, for a really great book. And thank you all as well for this really great panel. It's been fascinating.
Okay, thanks, Pete. Tom.
Well, I agree that it's a wonderful piece of work, a great book, and there's so much to learn from it. I would simply say that in moving forward, because I do agree that with my fellow panelists that some deeper, more radical thinking will be needed in the future, and I would suggest that journalism needs to take more responsibility for asserting what it stands for and incorporating those sorts of ideas into regulation of online material is not at all inconsistent with freedom of speech.
Okay, thanks, Tom. Irini, I'll hand over the last word to you.
Yeah, well, first of all, thank you all for your very insightful comments, and I agree that I like the fact that we end our conversation on a positive note, that there is a way out for journalism out of the difficulties it currently faces, if it only manages to more clearly articulate what it stands for, and to and also make it a reality that it is different, that it stands above the ocean of content that for quality content that exists online. So I think that's a hope, and perhaps can pave the way for the future for the digital press.
Okay, thanks, Irini. Okay, in that case, I'll bring things to a close. So I should obviously say thanks to a few people. We should first of all thank Irini for writing such a great and important book. We can see just the sheer range of issues that it raises from the discussion that we've had today. I'd also like to thank our three panelists for their contributions as well, Peter Coe, Tom Gibbons and Bernd Holznagel. And also finally, I'd like to thank Sophie Churan and the British Association of Comparative Law and the University of Cambridge for organising and co-hosting this event. Okay, thank you very much.